Welcome to Details in Divorce, where we break down the legal, financial, and emotional aspects of divorce to help you make informed decisions. I'm your host, Paul Riley, and each episode we dive into key issues that impact individuals navigating separation and divorce. So, whether you're concerned about asset division, protecting your business, or dealing with foreign property disputes, we are here to provide clear and practical insights. Divorce is complex, but understanding your rights and options can make all the difference. And while this isn't legal advice, it's designed to empower you with the knowledge you need to move forward and to move forward with confidence. Imagine this scenario. You've built a $10 million portfolio over 15 years of a common law relationship. Your partner managed the home and supported your career. Now you're separating, and they want half of everything you've accumulated. If you're married in Ontario, the Family Law Act would automatically split your wealth 50-50, but here's the catch. Those equalization rules only apply to married spouses. Section 5 of the Family Law Act makes that abundantly clear. Common law partners are excluded. That statutory distinction changes everything. The Supreme Court of Canada's position is that common law partners must rely on equitable doctrines like unjust enrichment and constructive trust, not equalization when trying to claim an interest in high-value assets like homes, cottages, corporations, or investment properties as well. There's no presumption of a 50-50 split. Instead, claims succeed or fail based on evidence of contributions, enrichment, and fairness. Today, I'm going to show you exactly how Ontario courts approach property division in common law breakups, highlight the leading cases, and explain why understanding these rules could save or cost you millions of dollars. Let's start with the reality. In Ontario, common law partners have zero automatic right to property division. The Family Law Act is crystal clear. Its equalization provisions apply only to married spouses. This means no automatic 50-50 split, no presumption of equal contribution, no guaranteed payout. But don't celebrate yet, because while there's no automatic division, common law partners can still claim significant portions of your wealth through three powerful legal doctrines, and I'm going to take you through them. They are unjust enrichment, constructive trust, and joint family venture. And I've had to do trials on all of these things. And let me tell you, courts are increasingly willing to use these tools to award substantial remedies, sometimes exceeding what married spouses would receive. Unjust enrichment is the nuclear weapon of common law property claims. It has three elements, and if your ex-partner proves all three, they can claim a share of your wealth. 1. Enrichment. Did you accumulate wealth during the relationship? For high net worth individuals, this is usually obvious. Your portfolio grew, your business expanded, your real estate appreciated in value. 2. Corresponding deprivation. Did your partner sacrifice something? This could be career advancement, educational opportunities, or simply providing unpaid domestic services that freed you up so you could focus on building wealth. 3, no juristic reason. This means, was there any legal reason why you should keep all this wealth? Courts will look for a contract, explicit agreements, or clear evidence of gifts. This framework traces back to the Supreme Court in Petkus v. Becker, a 1980 case, and was reinforced in Peter v. Bedlau, that was in 1993, where the court recognized that even unpaid domestic services can ground a claim. Here's the critical insight. Ontario courts have rejected the idea that simply being in a relationship justifies unpaid contributions. But they've also made it clear that if someone sacrifices their own opportunities to support your wealth building, the enrichment becomes unjust. Let me show you how these principles play out with real money. In Mullen v. Sherlock, a woman gave up her architectural career to help build their partner's medical business. For over a decade, she worked in the business for below market wages and managed their household. When they separated, the business was worth $6 million. The court didn't just award her back wages, they found she was entitled to 50% of the business value. That's a $3 million judgment. Or consider Jackson v. McNee. After 18 years together, the court awarded the woman $386,000, representing an equal division of 3 properties acquired during their relationship, despite all titles being in the man's name. In Cloutier v. Francis, the court recognized the partner's sacrifice of her military pension to support her spouse's career and awarded her $57,000, showing that even non-financial sacrifices tied to wealth creation can result in compensation. This brings us to the most dangerous concept for high net worth individuals, the joint venture. The Supreme Court of Canada in Kerr v. Vanas introduced this concept, asking courts to look at 4 factors. 1, mutual effort made toward common goal. 2, economic integration of your finances. 3, actual intent to share wealth. And 4, prioritizing the family unit. Cases like Brennan v. Forney and Cameron v. Vincent shows that Ontario courts apply this method. In Brennan v. Forney, a partner's career sacrifices led to equal division of the family's home, but also RESPs, even though almost all funds came from the other partner. In Cameron v. Vincent, the court compensated pension losses because domestic roles delayed one spouse's career. The result, once a joint family venture is found, courts often split wealth close to 50%, regardless of legal title. Here's what's particularly treacherous. You don't need explicit agreements. Courts infer joint ventures from conduct. Did you pool resources, make major decisions together, sacrifice individual goals for family ones, present yourself as an economic unit? And once a court finds a joint family venture, they don't calculate damages like an employee seeking back wages. Instead, they ask, what's this person's proportionate share of the wealth that they created together? And that answer is often 50%, even when legal title says otherwise. When courts find unjust enrichment, they have 2 remedy options, money or a constructive trust. Money is the default, but constructive trusts are the nuclear option. The Supreme Court of Canada in Peter v. Bablau made clear that constructive trusts are exceptional, used only where money is inadequate and contributions directly relate to a specific property. In Sun v. Kwan, a mother contributed $290,000 to help buy a family home. When the relationship ended, she didn't just get her money back, she got 50% ownership of the property that had appreciated significantly. Ontario courts have repeated this principle in Lesko v. Lesko and Iredale v. Dougal, stressing in those cases that monetary awards come first and constructive trust only applies if there's a clear nexus between contributions and property. A constructive trust gives your ex-partner actual ownership rights in your property, not just the debt you owe, actual ownership. This means they become legal co-owners of your assets. They share in post-separation appreciation. They have rights that survive even if you can't pay. Courts impose constructive trusts when they find a direct link between your partner's contributions and specific property. For high net worth individuals, this distinction matters enormously. A $500,000 monetary award is manageable. A 50% constructive trust on a $10 million portfolio, well, that's life-changing. Ontario courts are becoming increasingly sophisticated and aggressive in these claims. 3 trends should get the attention of high net worth individuals. First, the value survived calculation. Courts aren't just looking at what your partner contributed, they're looking at what wealth survived the relationship and asking what portion your partner should deserve. Second, the expansion of contributions. Courts now recognize that managing a high net worth household Providing networking support and enabling career focus are valuable contributions that merit substantial compensation. And third, the disproportionate retention theory. Even if both partners benefited from the relationship, if you retain significantly more wealth, courts view this as presumptively unfair in a joint family venture. Recent cases like Cameron v. Vincent and Brennan v. Forney shows that the courts award hundreds of thousands or millions to partners who enabled wealth accumulation even when their direct financial contributions were limited. So, how do you protect yourself? Well, there are 3 essential strategies, and make note on these. These are vitally important. First, cohabitation agreements. You've heard me say this repeatedly. These are your best defense. Properly drafted agreements can define what's separate property, limits claims on business growth, and establish clear expectations about contributions and entitlements. The courts loathe to break up an agreement. The court feels that if 2 reasonable people get legal advice and sit down and agree to terms and sign a contract, then that contract should stand. It's very difficult to penetrate an agreement signed by 2 reasonable people once they've had legal advice. Second, documentation and separation. Keep detailed records of asset sources, maintain some financial separation, and avoid conduct that suggests joint ventures. Having separate investment accounts, business entities, and clear boundaries does in fact matter. And third, regular legal audits. Your risk profile changes as relationships evolve. What started as a casual cohabitation can morph into a joint family venture without you realizing it. Regular reviews helps identify and address emerging risks. Remember, unlike married spouses, you have flexibility to define these relationships contractually, so use it. And let me leave you with this sobering reality. I've seen high net worth individuals lose 30, 40, 50% of their wealth in common law property disputes, not because they were legally married, but because courts found their relationships had become economic partnerships deserving of partnership level sharing. The law doesn't care about your intentions if your conduct says something different. And the financial stakes in these cases often exceed what married spouses would claim under the Family Law Act. Common law relationships offer both opportunity and risk. With proper planning, you can enjoy the flexibility of unmarried life while protecting your wealth. Without it, you may find yourself facing claims that dwarf what marriage would have cost. The choice and the protection is yours, but only if you act before it's too late. Well, that's it for this episode of Details in Divorce. We hope you found today's discussion insightful and valuable as you navigate your own divorce journey. Remember, every situation is unique, and getting the right information is key to making the best decisions for your future. If you have any questions or need guidance, the Riley Firm is here to help. Be sure to subscribe so you don't miss our upcoming episodes where we continue to explore the critical issues that matter most during divorce. I'll see you next time.